Companies Act, Section 451, Punishment in case of repeated default. Section 451 of the Companies Act, 2013 establishes a stricter punitive framework for companies and their officers who commit recurring violations under the Act. The Indian corporate regulatory system recognizes that occasional procedural lapses may occur and thus provides reasonable penalties for first-time offenses. However, when an entity repeatedly disregards statutory obligations even after being penalized, it reflects a deliberate or negligent pattern of non-compliance. To curb such behavior, Section 451 ensures that stricter sanctions are imposed if the same offense is committed again within a specified period. This provision plays a crucial role in maintaining corporate discipline, safeguarding stakeholder interests, and promoting a strong culture of legal compliance. 1. Applicability: repeated commission of the same offense. This section is invoked when a company, or any officer of the company in default commits an offense again after having already been penalized for the same violation. The focus is on repeated disregard of the law rather than an isolated failure. Thus, the provision applies only to recurring non-compliance and not to unrelated or dissimilar offenses. 2. Defined time window for identifying repeated defaults. The law sets a clear time period to classify an offense as a repeated default. The subsequent violation must occur within 3 years from the date on which the earlier offense was committed and punishment was imposed. If the time gap exceeds 3 years, the new offense will not be treated as a repeat offense. It will be viewed as a first-time violation, subject to regular penalties. This limitation ensures fairness by preventing perpetual punishment for distant past mistakes. 3. Scope of offenses covered under this section. A fine, imprisonment, or both fine and imprisonment. Therefore, the provision covers a wide spectrum of violations from administrative lapses to more serious governance-related offenses, ensuring that repeat offenders cannot exploit gaps in the law. 4. Enhanced penalty for repeated non-compliance. The core consequence of this provision is escalation of punishment. In the event of repetition, the fine shall be twice the amount of the penalty originally prescribed for that offense. If imprisonment is also a part of the punishment under the relevant offense, the officer in default may still face the prescribed imprisonment term, in addition to the doubled fine. This doubling of penalty acts as a strong deterrent against habitual defaulters. 5. Objective behind stricter punishment. The enhanced penalty framework promotes compliance through preventing a casual or negligent approach toward statutory obligations, encouraging companies to implement corrective measures promptly after a first offense, sending a message that repeated violations will not be tolerated. By progressively increasing the severity of consequences, the law discourages willful or careless disregard for corporate regulations. 6. Accountability and responsibility of officers in default. This section recognizes that compliance is driven by human decision-making and oversight. Therefore, officers responsible for corporate compliance bear personal liability. They cannot hide behind the corporate entity to avoid punishment. This ensures heightened responsibility among directors, company secretaries, and other managerial personnel, strengthening internal governance structures. 7. Protection of stakeholders and public interest. Enhances investor and creditor confidence. Protects employees from mismanaged corporate behavior. Maintains trust in the corporate sector. Upholds public interest at large. For more details, contact us.